Good afternoon. I'm Joanne Lynn. I'm the Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs. I'm delighted to welcome you to our webinar entitled 8 Weeks, 8 Cases of Civil Rights Consequence in 2025. Today's virtual webinar is being recorded. I am joined today by two of my colleagues in the legal department, Ryan Downer, our legal director, and Caitlin Banner, our deputy legal director. And today we're going to be talking about 8 cases that we have filed in the first 2 months. I know many of us have talked about how long 2025 has already felt, and we at the Washington Lawyers Committee certainly concur, but we've also been firing on all cylinders and have been working around the clock to continue to advance racial justice and equity here in Washington, D.C., the greater DMV, as well as nationwide. Just to preview what our webinar is going to focus on today, I'm going to be talking about 2 national cases that we have brought in 2025, challenging new initiatives from the Trump administration with respect to civil rights and immigration. I will then transition to Caitlin Banner, our Deputy Legal Director, who will discuss 2 national racial justice cases involving private actors. One is the Proud Boys and the other one is the company Meta. And then finally, Ryan Downer will talk about 4 cases that we have brought to advance disability rights, fair housing, and prisoners' rights in the greater DMV. We will have the opportunity to be in conversation with all of you. If you have any questions throughout the webinar, feel free to type them into the Q&A function on the Zoom chat. We will see your questions as they come in. And after each of the speakers is presented, we'll look forward to being in dialogue with all of you. So thank you again. So here we are. It's March 4th. We are 2 months and into 2025, 8 weeks in. And it has been quite a time for Washington, D.C., the DMV, and for the country. At the Washington Lawyers Committee, we feel like we are tailor-made for this moment. We were established in 1968 in the aftermath of the assassination of Dr. Martin Luther King, at a time when Washington, D.C. and other cities around the country were literally on fire. And out of that grew a commitment and a committee of private civil rights lawyers who were committed to ensuring that low-income communities of color continue to advance and thrive and avail themselves of the full benefits of our Constitution and the American dream. And for the last 56 years, we at the Washington Lawyers Committee have been partnering hand in glove with Washington, D.C.'s top law firms to advance racial justice and equity. And that includes cases advancing immigrant justice, women's rights, education equity, disability rights, fair housing, workers' rights, prison reform, and criminal legal system reform. So, on January 20th, Donald Trump was inaugurated as president. On his very first day, just as he was going to the inaugural balls, he signed an executive order seeking to end constitutional citizenship for children born on U.S. soil. Never before has a president sought to do that, to end constitutional birthright citizenship. Ariel, can you go to the next slide? Thank you. Birthright citizenship is enshrined in the U.S. Constitution, dating back to 1868 with the ratification of the 14th Amendment in the aftermath of the Civil War. And that amendment guarantees that children born on U.S. soil are U.S. citizens by virtue of the Constitution and are therefore entitled to equal protection under law. That has been the law of the land for over 150 years. And in 1898, the U.S. Supreme Court addressed this issue head-on in a case involving a Chinese man born in California to 2 Chinese parents, the Supreme Court unequivocally stated that he, by virtue of being born in the United States, was a US citizen at birth. So for the past century, every Congress, every court, and up until now, every president has recognized this to be the law of the land. On January 20th, President Trump signed an executive order seeking to end birthright citizenship. On January 30th, the Washington Lawyers Committee, partnering with CASA, partnering with Asian Americans Advancing Justice, filed a lawsuit on behalf of Organization for Chinese Americans. That lawsuit was filed in the U.S. District Court here in Washington, D.C. As you know, there have been multiple lawsuits challenging the president's executive order on birthright citizenship, and they've been filed in various districts across the country. Several judges have issued preliminary injunctions, which means there's a temporary hold on the executive order while these cases continue to be litigated in the courts. The Trump administration has not backed down from this executive order. They remain intent on trying to end birthright citizenship. So this fight will continue its way through the courts. The second case that we brought a challenge to concerns temporary protected status for Venezuela. So under our immigration laws, the president and the Homeland Security Secretary have the option of designating TPS, temporary protected status, for certain countries. And customarily, we see the president use this power in cases of natural disaster, war, conflict, conditions which make the living conditions in that country basically untenable. So President Biden issued TPS for Venezuela in recent years. And on February 5th, the new Homeland Security Secretary, Christine Noem, announced plans to do away with TPS for Venezuelans. On February 20th, the Washington Lawyers Committee, on behalf of CASA and Make the Road New York, both immigrants' rights organizations, we went to court here in Maryland and filed a challenge to the Homeland Security Secretary's unlawful attempt to end TPS for Venezuelans. Our lawsuit was brought on behalf of Venezuelans residing in the DMV, as well as Venezuelans across the United States. Approximately 600,000 Venezuelans stand to lose TPS by the end of 2025 if the president's executive order goes into effect. So we are moving on this case in a very expedited manner, seeking the court to address this issue as soon as possible, certainly by early April, when the first deadline is set to hit the Venezuelans on TPS. With that, I am now going to turn to Caitlin Banner, who is going to update us on two major cases involving racial justice at the national level, including one major victory. Caitlin.
Thank you, Joanne, and I'm excited to be able to talk about a victory in these times when we know that civil rights and racial justice and those principles that we all hold really dear are under attack. As folks may know, the Washington Lawyers Committee, along with our partners at Paul Weiss and at the Lawyers Committee for Civil Rights Under Law, filed a lawsuit in December of 2020 against the Proud Boys and violent extremists that marched in Washington, D.C. and attacked the Metropolitan African Episcopal Church. And when they attacked the church, Metro AME, which is a historic Black church in downtown DC, they trespassed on the church's property. They ripped down a Black Lives Matter banner and otherwise acted in ways to intimidate the church, its reverend, and the congregants who go there. And so we sued the Proud Boys and the individual defendants for this attack on the church. And many months ago secured a default judgment against the Proud Boys and individuals for more than $2 million. And what we had a great victory in is, as part of our efforts to collect against that debt, the Proud Boys nor the individual members have not yet satisfied their debt to the church. And so we asked a judge to transfer the Proud Boys trademark and all the proceeds that they get from that trademark to Metropolitan AME. And so this was really a creative legal strategy, I think, to try to both satisfy this judgment and to ensure that the Proud Boys cannot continue to profit off of their name and profit off of the hate and the violence that that name has come to represent. We know that the church has a long history of standing up for justice and against all forms of hate, and this is one of the ways that they are using to hold the Proud Boys accountable. And it's really, I think, fitting that the money that the Proud Boys raise in membership dues and merchandise sales off of their trademark now goes to fund the works of this great church. And so we're really excited to see this victory come through during the last month. And then we can go on to the next slide. The other thing that I am really excited to tell everyone on this call about is another new lawsuit that we filed along with the Lawyers Committee for Civil Rights Under Law and Emery Chelly, which is a lawsuit on behalf of the Equal Rights Center against Meta and its social media networks, Facebook and Instagram, for its discriminatory ad delivery practices. So this is a groundbreaking lawsuit that alleged that Meta's ad algorithms discriminate against Black users because they disproportionately serve them one type of ad while serving white users a different type of ad. And we are particularly looking at about how advertisements for higher education opportunities are delivered. So what studies have shown is that Black users are more likely to receive advertisements for predatory for-profit institutions. And so these are the types of institutions that often provide lower quality education. They charge high tuition rates and do not spend those dollars, those tuition that they collect on services that students need. These are the types of schools that have had nearly 24,000 federal fraud complaints filed against them. For lying about graduation rates, about incomes, or about employment statistics. And unfortunately, what studies have shown is that the ads for these kinds of institutions are disproportionately delivered to Black students, and the advertisements for public universities or nonprofit universities, the universities we sort of aspire to for our young people, are disproportionately delivered to white students. And so what we know is that this has the effect of denying Black students information about important educational opportunities because of their race, and it instead steers them towards these for-profit schools, which we allege provide lower quality education at a much greater cost. This lawsuit, I think, is a foray into the way that digital discrimination shows up, and we really hope that as a result of this lawsuit, we're going to see an end to discriminatory ad steering, that we're going to hold Meta accountable for the algorithmic discrimination that we allege in the complaint, and really set some precedent around fairness in digital advertising, because we know that this is something that affects all of our lives. And with that, I will turn it over to my colleague, Ryan Downer, to talk about some of our other cases and victories in the Washington, D.C. area.
Thanks, Caitlin, and thank you all for joining. As you've just heard, there are multiple cases on our docket right now that have national implications. That's really by virtue of the political environment that we find ourselves in, but the committee is more committed than ever to our core priority of making life better for vulnerable communities in the DMV, with a primary focus on housing, workers' rights, prisoners' rights, education, and disability. And I'm going to briefly touch on several cases that hit those areas. In the past few years, our workers' rights team has brought a series of wage theft cases, largely on behalf of immigrant workers in the DMV. This has become a key priority by necessity. We keep encountering this issue of vulnerable workers being preyed upon by the people that employ them, being stolen from by the people that employ them, and finding themselves with little recourse. Some of our clients find us through our workers' rights clinic, which we run every week virtually and in person monthly. And some contact us through our relationships with local organizers. In the current political environment, I expect this to be an issue that's even more prevalent over the next few years, and our efforts to combat it will rise to that. Today, I'm highlighting our recently settled case against Long Fence. If you've driven or walked by construction sites in the district or in Maryland or in Virginia, then you've probably know Long Fence or at least seen the signs. WLC and co-counsel Murphy Anderson filed a wage theft lawsuit on behalf of 5 Latino construction workers against them and another defendant. Our clients had worked 9 to 10-hour shifts every day, assembling and installing fences for residential construction work sites in Maryland and in DC for well below minimum wage, not getting the overtime they were entitled to. These workers also erected security barriers at the United States Capitol building. I'm sure you all remember those, sometimes working for over 16 hours a day. After filing and some initial litigation, we went to mediation and were able to resolve that case with a significant settlement, $370,000. These are cases that don't usually make headlines, but that resolution is just highly, highly significant to our clients, who are working people who are just trying to take care of their families day to day and who do such important work in the community. So this was a major victory for our clients, and notably, I just greenlit a new wage theft case to be filed imminently last week. So the struggle continues on this front, and this is going to be a major priority for us moving forward. This past January, along with Wiley Rain, we filed a case on behalf of Disability Rights Maryland against the Maryland Department of Public Health for the wrongful pretrial detention of certain criminal defendants. And boiling this down, this issue is about people being held in jail when they're not supposed to be in jail. By law in Maryland and really everywhere else in the country, only those who are found competent to stand trial can face a jury for a criminal offense. Those who are found incompetent to stand trial have to receive timely and appropriate mental health care and support services. And the purpose of those services is to restore the individual to competency so that they can be tried if possible, and for them to receive treatment. For anyone who's found IST, incompetent to stand trial, and dangerous, the combination of those two, MDH is required by state law to transfer them to an MDH facility within 10 days of receiving the court's order. So that means they have to go to a secure hospital and get services. And that's just not what happens in a lot of these cases. Instead, hundreds of mentally ill Marylanders are left in county jails for weeks or months at a time with no access to treatment or medications. Many are put in solitary confinement. Because of that, folks decompensate further as a result of their prolonged pretrial incarceration. And again, this is a class of people who are expressly not supposed to be in jail for a prolonged period. They're supposed to be getting treatment. And these are people who have not been found guilty of anything. We've also alleged that MDH makes determinations of dangerousness not based on the facts, but based on stereotypes about people with mental illness, meaning that some people are being determined to be dangerous without sufficient evidence to back that finding. More than 40% of those adjudicated IST and indefinitely detained were charged with misdemeanors or nonviolent felonies. So these are people who likely could receive treatment in the community. But there's this default assumption that anyone who's mentally incompetent must be dangerous and require confinement. And we give several examples of this in the complaint, and I'll just briefly tell one of them here. One of the folks who's affected, his initials are TD. He was initially found IST and dangerous by an MDH evaluator, but as his felony charge was dropped, and MDH's evaluator revised the report, finding that he was not dangerous and recommending that he be transferred to community-based services. The judge agreed with that, agreed to the release, but because MDH failed to create a plan of services for him to get those treatment services in community, he was kept in prolonged detention for 5 additional months, which is an eternity in terms of the havoc that wreaks on people's lives. So those are the sorts of issues that our case is dealing with on a systemic level in Maryland. And finally, I'll turn to housing. In recent years, WLC has had a real focus on housing conditions work, basically making sure that landlords provide decent and safe places to live. And the other focus that our housing team has had has been on removing artificial barriers to housing access. So looking at unlawful tenant screening practices like blanket criminal records bans, or discrimination against voucher holders. Last month, we entered, or I should say, re-entered an area that's for us both old and new. We're representing the Equal Rights Center along with Kroll, Mooring, and Handley Farah. We filed 2 complaints alleging design and construction violations at properties in DC and in Baltimore. This is an area of law where WLC once had an active docket, but it's been not active in a while. For those of you who may not be as familiar with this area of law, the Fair Housing Amendments Act of 1988 added protections for people with disabilities, requiring that certain types of housing meet basic accessibility standards. DC law has similar provisions, and these laws require that wheelchair users and others with disabilities have fair access, that literally physical barriers to access be removed. We filed suit against the owners of Bonsai Apartments. That one's in DC and Superior Court for several accessibility issues across different units. Covered units have doorways that aren't wide enough for a wheelchair user to get through, or bathrooms that don't have enough clear floor space for a wheelchair user to use. Some common areas like the rooftop decks weren't accessible at all to folks in wheelchairs. We also filed a HUD complaint against the owners of the Brixton building in Fells Point down in Baltimore. ERC's testing uncovered a very similar pattern of inaccessibility there. And there's a real shortage of accessible housing in DC and in Baltimore and throughout the region. There's just simply not enough homes and apartments available for wheelchair users, even despite the fact that the laws on this are very, very clear. So we felt it was important to begin reinitiating the committee's commitment to design and construction in the DMV. And so with that, I will yield back to Joanne.
Thank you so much, Ryan and Caitlin. As you can tell, we have just gone through 8 major cases very quickly. And we know that's a lot of information to absorb and digest, but we want to use the remaining time to hear from all of you. So we encourage you to write your questions in the Q&A box. It should be at the bottom of your Zoom menu. When you look at the Zoom screen, there's a box with a question mark and says Q&A. Go ahead and write in your question. The speakers will see the question, and then we can go ahead and address that. So as the questions are queuing up, one question that has come in, and this is for both Ryan and Caitlin. We see a lot of activity from different courts around the country with respect to the Trump administration's initiatives. And at the same time, we know that the Supreme Court is not friendly to civil rights. What do you think are the prospects here in terms of the federal courts being able to safeguard our constitutional civil rights?
I mean, I think there are still opportunities to bring cases that can be effective in providing immediate relief to folks. It's unclear what's going to go to the Supreme Court and what's going to resolve earlier than that, for one thing. And we've already seen some early victories with TROs being granted, preliminary injunctions being granted, including in the birthright citizenship cases. And there's also some things that are happening that are so clearly beyond the pale legally that it's we'll see, but I have some degree of hope that for some of the things that are not all that controversial or shouldn't be all that controversial in terms of their legality, that we can still prevail on those even in the Supreme Court. In terms of our local practice, I know this wasn't the question, but we have been thinking a lot about alternatives to federal court. And so the last 2 cases that I mentioned, you noticed, or you may have noticed that we were not in federal court on those two cases. And that's an intentional choice that we often make depending on how likely we think victory is in a particular forum or what avenues of relief are available, and other considerations. But I think we have to stay flexible and thoughtful about where we're going with particular types of issues.
Yeah, I'll
Thank-
just add one thing onto that, which is to say also is that we I think need to use the laws that we have. And so even recognizing that there may be that we may lose sometimes, or that the Supreme Court, if things get all the way up to the Supreme Court, may not come down in our favor. I think that we can't then not enforce the laws that we have, not try to secure the rights of the individuals and the communities that we work with. And so I think you can see from our docket, it really reflects are exercising the legal rights of the communities that we work with, to see, as Ryan said, where we can push back, where we can delay, where we can secure victories.
Thank you, Ryan and Caitlin. We've also received another question. We're expressing this feeling that many of us have, feeling overwhelmed and despairing, given all the threats and challenges to civil rights, immigrants' rights, human rights at this time. Can you give us your assessment and your outlook as to whether or not you think there are opportunities to not only safeguard our rights, but to even advance civil rights in 2025?
No, I think the only avenue can't be what we're doing in the courts. I think WLC's specialty and value add is litigation. But I have been inspired to see, the work that others are doing in other types of litigation around and across the spectrum, but also other forms of advocacy. And I think that is going to be required to get us through this really rough period. Folks, we can't rely solely on the courts. I think the courts have a really important role to play. And I have been trying to focus my energy on the space that I can control. And that space is bringing cases where we see that the rights of the communities and people who are vulnerable are being attacked. And so we'll continue to do that. We'll continue to work with our partners to bring those cases, to pursue those campaigns. And I think that's the best we can do, is like in our own individual spaces and collectively come together and use our talents to protect what we need to protect.
We have time for one final question. And so this is along the lines of the Washington Lawyers Committee and how we see our identity and our history as the community's civil rights lawyers. And at a time when a lot of people are under attack, how do people get in touch with the Washington Lawyers Committee if they have a case, or if their school or church or neighborhood is under threat?
Yeah, I can talk about two things. So one, you can always go to our website, which is www.washlaw.org. There is a Get Help button, and that is an opportunity to raise that issue, and those are reviewed regularly by our legal program team. We also, we know that in the DMV right now that there are many workers who have been impacted, both federal workers and other workers who may need to seek legal advice. And as Ryan mentioned, we have a weekly workers' rights clinic where folks can come and get free legal advice and referral on a wide range of employment justice issues and workers' rights issues. And again, that information is on our website, and really encourage folks to share that widely, and to, if you are seeking legal help, to come to clinic, because that is a great opportunity to touch base with an employment lawyer.
And I'll just add, specifically, if there are any federal workers on the call or folks who are affected, we have not branched into that area ourselves, but I have a long referral list of federal employment lawyers. If you need Legal advice, you should reach out to me directly, Ryan_Downer@washlaw.org, and I'm happy to put you in contact with folks who do this, whether it's an individual case or an across-the-board challenge. We have referrals for folks.
Thank you, Caitlin and Ryan. Yes, and these are unprecedented historic times. So at the Washington Lawyers Committee, it is not business as usual. We are doubling down, ramping up, intensifying our efforts to try to meet this moment. This is a civil rights moment for the country and for our history, and we are giving it all with our tremendous pro bono partners to meet the challenges. We want to hear from you. We truly are the DMV's civil rights lawyers, and that's not just Washington, D.C., that extends out to rural Virginia and Maryland. Please be in touch with us. And we need to hear from you so we can figure out what are the best responses to the threats out in the communities there. Thank you again for your interest, your support, and your partnership. We at the Washington Lawyers Committee will continue to be in touch with you, and we thank you for joining us for today's webinar. Have a good afternoon.